Mr. President, I feel my speaking at this moment is appropriate because much of what I have to say follows logically from the last words of the presiding officer when he spoke recently on the USA Freedom Act, because I agree with the presiding officer when he said that we need a bill. We need to move forward and approve reforms and changes in the law that are contained in the USA Freedom Act. We may be in disagreement about some of the specifics. We may be in contention about the extent of the changes made, but there is a general consensus that this decade-and-a-half-old law is in need of some revision, and that the USA Freedom Act contains many, many important and genuinely worthwhile changes in the rules that will apply as the United States helps to protect our security, but also to safeguard and preserve essential rights and liberties. That's the balance that needs to be struck. A difficult balance in a democracy, one of the most difficult in an area where secrecy has to be maintained because surveillance is more useful if it's done in secret. But at the same time, rights need to be protected in an open society that prides itself on transparent and accessible courts. Changes in the rules are welcome, such as the end to the present system of bulk collection of phone data. We may disagree on that point. Changes in the rules that I support may not be supported by many of my colleagues. I believe the USA Freedom Act goes in the right direction on bulk collection of phone data by ending the current practice in its present form. What brings me here is not so much a discussion about the rules as the method of enforcing those rules and implementing and assuring that they are faithfully executed, which is the role and the responsibility of the Foreign Intelligence Surveillance Court in the first instance. There are means of appeal from that court, but as with many courts in our system, that one is likely to be the end destination on most issues, particularly since it operates in secret. The USA Freedom Act, again, goes in the right direction by making it more transparent and requiring disclosure of significant decisions and opinions when it is appropriate to do so, and under circumstances that in no way should involve compromising our national security, striking, again, a good balance. But this court, we have to recognize, is an anomaly in an open, democratic system. Its secrecy makes it an anomaly. It works in secret, hears arguments in secret, issues opinions in secret. Its decisions are almost never reviewable. And it is, unlike most of our institutions, opaque and unaccountable. Understandably so, because it deals with classified sensitive information, protecting our national security against threats that cannot be disclosed. When they are thwarted, in many instances, the success of actions resulting from the FISA court are most valuable when they are unknown to most American people. So this court is special. It's different. But let's not forget that if we were to say to the founders of this country, there will be a court that works in secret, has hearings in secret, issues opinion that are kept secret, and its decisions will have sweeping consequences in constitutional rights and liberties, they would say, that sounds a lot like the courts that were abhorrent to us, so much so that we rebelled against the Crown, who said in the Star Chamber, in courts that England had at the time, there's no need for two sides to be represented. There's no need for openness. Secret, one-sided courts were one of the reasons that we rebelled, and men and women laid their lives on the line, and they lost their homes and treasures and families and paid a price for open and democratic institutions. So we should be careful about this anomalous court that may be necessary, but we should try to make it work better than it has. And so transparency, the issuance of opinions, is very much a step in the right direction where the issues are significant and the transparency of those decisions is consistent with our security at the moment. There may be a delay, but we should remember that the bulk collection of phone data, which the United States Court of Appeals for the Second Circuit said was illegal, persisted for so many years because the decision itself was never made known to the American people. There's another reform that I think is equally, if not more significant. Courts that are secret and one-sided are likely to be less successful, not only because they're secret, but because they're one-sided. And so, as part of this reform, I've worked hard and in fact proposed for the first time a bill that would create an adversarial process, two sides represented before the court. A bill that I sponsored in 2013 to reform the Foreign Intelligence Surveillance Court, in fact, was joined by 18 co-sponsors. I thank them for their support, both sides of the aisle, and the basic structures that I propose are reflected in the USA Freedom Act today. Colleagues worked with me and have since on formulating that bill and arriving at this moment where the central goals would be accomplished by Section 401 of the USA Freedom Act, which provides for the appointment of individuals to serve as amicus curiae, friends of the court, in cases involving a novel or significant interpretation of the law. That provision would be egregiously undercut, in fact, gutted, by McConnell Amendment 1451, because it would prevent these lawyers, the amicus curiae that would be selected by the court, from obtaining the information and taking the actions they need to advance and protect the strongest and most accurate legal arguments, and thus really eviscerating the effectiveness of this provision as a protection. It's a protection of our rights and liberties because these amicus curiae would be public advocates protecting public constitutional rights. And they would help to safeguard essential liberties, not just for the individuals who might be subjects of surveillance, whether it be by wiretap or other means, but for all of us. Because the Foreign Intelligence Surveillance Court is a court. Its decisions have the force of law. Its members are Article III judges selected to be on that court, sworn to uphold the law, both constitutional law and statutory law. And so this provision, in my view, is fundamental to the court as a matter of concept and constitutional integrity. That integrity is important because it is a court, but it's also important to the trust and confidence that people have in this institution. I was a law clerk to the United States Supreme Court, specifically to Justice Blackmun, and I well recall one of the justices saying to me, "You know, we don't have armies, We don't have police forces. We don't have even the ability to hold press conferences. What we have is our credibility and the trust and confidence of the American people. That is so fundamental to the courts of this nation, who consist of judges appointed for life without any real direct accountability, as we can be held to be through the elective process. The Foreign Intelligence Surveillance Court has taken a hit in public trust and confidence. There's a question about whether the American people will continue to have trust and confidence, and whether that sense of legitimacy and credibility will continue. And the best way to assure it is to make the court's process as effective as possible, not just in the way it operates, but the way it is seen and perceived to operate, the way the American people know it should operate, and the way they can be assured that their rights are protected before the court by an advocate, an amicus curiae, who will protect those rights of privacy and liberty that are integral to our Constitution and the reason why the founders rebelled against the English. But there is another reason why an advocate presenting the side opposing the government is important to the Foreign Intelligence Surveillance Court, and that is everybody makes better decisions when they hear both sides of the argument. Judges testified at our hearings in the Judiciary Committee about the importance of hearing both sides of the argument, whether it is a routine contract case or a criminal trial, where, by the way, often a judge's worst nightmare is to have the defendant represent himself because the judge is deprived, and so is the jury, of an effective argument on the other side of the government. And so too here, we were told again and again and again by the judicial officers who testified before our committee, and I've heard it again and again and again as I've litigated over the last 40 years, that judges and courts work best when they hear both sides. I have no doubt that the judges of the FISA court believe as strongly in constitutional rights and implementation of constitutional law as anyone in this body, including myself. I have no doubt that the government litigators who appear before the court representing the intelligence agencies seeking warrants or other action and approval by the court have a commitment no less than anybody in the United States Senate, including myself, to those essential values and ideals. But courts are contentious. They are places where people argue, where different sides are represented, different views of complex questions, and these issues before the court are extraordinarily complex. They also involve technology that is fast changing and often difficult to explain and comprehend, and easily minimized in the consequences that may flow from approval of them. And so the USA Freedom Act would provide for, in effect, a panel of advocates and experts with proper security clearances that the court can call upon to give independent, informed opinions and advocacy in cases involving a novel or significant interpretation of law. Not every case, not every argument, but where there is, for example, the issue of whether the statute authorizes the bulk collection of phone records. I tend to think that the outcome would have been different in that case if the court were given the opposing side of the argument that eventually prevailed in the United States Court of Appeals for the Second Circuit by a unanimous bench. So the court really deserves this expertise. It deserves the other side, and it deserves to hear both sides of the argument. And just to clarify, those two sides of the argument should not be in any way given so as to detract from the time necessary. If there's an urgency, the warrant should be issued and the arguments heard later, just as they are in a criminal court. When there's an exigency of time, and I've done it myself as a prosecutor, the government's lawyer should go to the judge, be given approval for whatever is necessary to protect the public or gain access to records that may be destroyed or otherwise safeguard security, public safety. And that should be the rule here too. Now, in the normal criminal setting, at some point, a significant issue of law is going to be litigated if the evidence is ever used. And that's the basic principle here too. If there's a novel or significant issue of law, it should be litigated at some point, and that's where the amicus curiae would be involved. Security clearance is essential. Timing is important. And there should be no compromise to our national security in the court hearing the argument that the advocate may present on the other side. It can only make for better decisions. In fact, it will benefit all of our rights. These provisions were written in consultation with the Department of Justice attorneys who advocate before the FISA court. They're supported by the Attorney General and the National Director of Intelligence. They reflect the balance and compromise that appear throughout the USA Freedom Act. Amendment 1451 would upset this balance. It would strike the current provisions providing for the appointment of a panel of amicus curiae, the provisions that represent a carefully crafted balance, and it would compromise those provisions in a way that need not be done because this balance has the support of numerous stakeholders, from civil liberties groups to the intelligence community, and it would replace this balance, this institution, with an ineffective, far less valuable advocate. There's no need to water down and undercut and eviscerate the role of the independent experts by removing requirements for the court to appoint a panel of experts to be on call, for the experts to receive briefings on relevant issues, and significantly to provide those experts with access to relevant information. Those provisions are unnecessary and unwise, and therefore I oppose strongly Amendment 1451 because it does unnecessarily and unwisely weaken the role of these experts and amicus curiae. Equally important, Amendment 1451 would limit access and significantly restrict the experts in their going to legal precedents, petitions, motions, or other materials that are crucial to making well-reasoned argument. It would restrict their access unnecessarily and unwisely, and thereby endanger those rights and liberties that the advocates, the public advocates, are there to protect. And it would also restrict their ability to consult with one another and share insights they may have gained from related cases, as government attorneys are currently able to do. By undercutting these essential abilities and authorities, this amendment would hamstring any independence, both in reality and in perception, and thereby also undercut the trust and confidence that this act is designed to bolster and sustain. In short, I know that many people of good conscience may disagree over the best way to reform this law. I accept and I welcome that fact. I welcome also my colleagues' recognition that an amicus curiae procedure in some form would benefit this court. But I urge my colleagues to reject an amendment that would lessen its constructive and beneficial impact. We've already delayed long enough. This amendment would not only weaken the bill, it would exacerbate the delay by sending this bill back to the House. And we all want to avoid a very, very potentially troubling delay in approving this measure. I have been dismayed by the divisions and delay that have prevented us from finally approving the USA Freedom Act before the existing law expires. We should move now. We should act decisively. We should adopt the USA Freedom Act without Amendment 1451, which would simply further erode the trust and confidence, the legitimacy and credibility of the Foreign Intelligence Surveillance Court. I urge my colleagues to join me in voting against this amendment and passing the USA Freedom Act in its current form, avoiding the delay of sending it back to the House and then potentially it coming back to the Senate, so that we can tell the American people that we're protecting the strongest, greatest country in the history of the world from some of the most pernicious and perilous terrorist forces ever in the world's history. Thank you, Mr. President. I yield the floor. I suggest the absence of a quorum.
If the senator would hold his request, we may have another member who would like to speak.
I will withhold my request, and I would just add, while we're waiting for my colleague to take the floor, that I want to join a number of my colleagues I'd intended to speak separately, and I ask that this part of my remarks be printed separately.
Without objection.
I join many of my colleagues in our feelings and expression of deep sadness on the loss of Beau Biden, one of our nation's greatest public servants, one that I was privileged to join in serving with as Attorney General. He is Attorney General of Delaware and I of Connecticut. I knew Beau Biden well and, in fact, sat next to him at many of our meetings of the National Association of Attorneys General. There was no one I met as Attorney General who was more dedicated to the rule of law, to protecting people from threats to public safety and respecting their rights and liberties in doing so. And his loss is really a loss to our nation, as well as to the Vice President's family. My hearts and prayers go out to them. I know how deeply the Vice President loved Beau Biden and how much as a dad his death will unspeakably and unimaginably affect him. And so I want to express on behalf of Cynthia and myself our thoughts and prayers which are with the Vice President and his family at this point. Thank you, Mr. President. I yield the floor.